Denied? You could be deported immediately. In 2025, a green card denial doesn't mean you start over. It could mean you're headed straight into deportation proceedings. One denial is now enough for USCIS to issue a notice to appear in immigration court. This is the new reality for marriage-based applicants. Even couples who played by the rules, legally married, living together, and waiting patiently, are finding themselves in removal proceedings after a single rejection. USCIS updated its enforcement policy. If your case is denied, you may no longer get a second chance. Instead, you could receive a court summons within weeks, and be at risk of being removed from the U.S. Real couples. Real denials. Real deportation risk. One recent case involved a newlywed from Honduras who had filed all paperwork correctly. But during his honeymoon, ICE detained him because an old removal order surfaced. He was held for 141 days, with no resolution. Another case involved the wife of a U.S. Marine. She was arrested while her marriage-based case was pending, all because of a previously dismissed deportation order. She was separated from her baby during the legal chaos. These stories are no longer rare. With updated USCIS rules and ICE coordination, many marriage-based green card applicants are one denial away from being treated as if they never had a case to begin with. If you're denied, timing is everything. The first thing to do is figure out what was denied. If your I-130 was denied, USCIS believes your marriage is not real. If it was the I-485, it likely relates to your legal status or immigration history. Sometimes, applicants panic when their work permit or travel document is denied. But those aren't the green card. They're linked to your main case, but they don't automatically lead to removal unless you ignore follow-up steps. It's critical to read your denial letter carefully. It explains exactly what went wrong and whether you have the option to appeal, refile, or respond with new information. And the clock starts ticking the moment it's issued. What if you're still together? What if you're not? If you and your spouse are still married and supportive, you may be able to refile or appeal. A second filing with stronger evidence, cleaner forms, and better preparation can often succeed where the first attempt failed. But if the relationship has broken down, emotionally or legally, your path becomes more complex. You'll need to explore options that don't require your spouse's support. And 2025 does allow for that in several situations. There are specific protections for those who have experienced abuse, abandonment, or even the death of a spouse. These paths are not easy, but they exist, and they can lead to permanent residency, even after denial. Option 1. Appeal the denial within 30 days. If you believe USCIS made a mistake, by overlooking your evidence or misapplying the law, you can file a motion to reopen or reconsider. In most cases, you only have 30 days to do it. Appeals are reviewed by the Administrative Appeals Office, AAO, or the Board of Immigration Appeals, BIA. But they take time, and unless your case is extremely strong, approval isn't guaranteed. Still, it may pause removal. Appeals are often best when you submitted everything correctly, but USCIS got it wrong. If your error was procedural or related to weak evidence, refiling might be a safer and faster alternative than going through the appeal process. Option 2. Refile with a stronger case. Many couples choose to start fresh. If your first application had missing documents, inconsistent answers, or outdated forms, it may be better to refile entirely with a corrected, well-supported package. Refiling gives you a clean slate, especially if your relationship is intact and your spouse is still willing to sign. But timing is everything. Refile quickly, especially if you suspect a notice to appear is coming soon. You may also want to submit your new case with legal support. An experienced immigration attorney can help present your case more clearly, avoid red flags, and reduce the chance of another denial. Option 3. VAWA, if your spouse abused or controlled you. If your spouse was abusive, emotionally, physically, financially, or even psychologically, you may be able to self-petition under VAWA, the Violence Against Women Act. This lets you apply without their help or knowledge. VAWA isn't just for physical violence. It covers manipulation, threats, isolation, and financial control. You'll need documentation, affidavits, and sometimes therapist or counselor letters. But many succeed, and USCIS is required to review these cases confidentially. VAWA filings are often a lifeline for those trapped in unsafe or coercive marriages. And unlike regular marriage petitions, you don't need your spouse's cooperation or signature to move forward. Option 4. I-751 Waiver, if you had a 2-year green card. If your marriage ended after receiving a conditional green card, you may still be eligible to remove the conditions using Form I-751 with a waiver. This allows you to prove the relationship was real, even if it didn't last. You can file with a divorce waiver, hardship waiver, or abuse-based waiver. The key is proving the original marriage wasn't fraudulent, even though it ended early. Many applicants win their waiver cases with strong evidence and timing. This option is powerful for those who feel stuck between a divorce and USCIS deadlines. But it requires a well-documented history of the relationship, showing it was genuine up until the time it broke down. Option 5, Widow Petition, if your spouse passed away. If your U.S. citizen spouse has died, you can still apply for a green card, but only if you file within 2 years of their passing. This is called a widow petition, and it bypasses the need for their signature. Widow petitions are emotionally difficult, but they exist to prevent families from being torn apart after a tragic loss. You'll need to prove the marriage was real and ongoing at the time of death. If you miss the 2-year deadline, the option is gone forever. So if your spouse passed recently and your case was never finalized, speak to an attorney immediately to preserve your eligibility before the window closes. Your 2025 survival checklist after denial. First, don't ignore the denial letter. Read it carefully, and take action within days, not weeks. Second, talk to a qualified immigration lawyer to evaluate whether appeal, refiling, or an alternative petition makes the most sense. Third, check the form additions and USCIS rules again. If you refile, make sure every form is the current version. And fourth, prepare a stronger evidence package, especially for marriage-based filings, with financials, photos, affidavits, and timelines. Finally, stay alert for any signs of a notice to appear. If you receive one, your green card case becomes a court case. You must respond, and quickly, or you could be ordered removed in your absence. Final thoughts: denied doesn't mean defeated. In 2025, one mistake on a green card application can change your life. But a denial is not the end. You still have power and options if you act fast, stay informed, and don't give up. USCIS may be tougher now, but immigrants are tougher too. Whether you choose to appeal, refile, or file independently under VAWA, your path forward still exists. Just don't wait for the system to give you permission. This is not the time to freeze. This is the time to move, quickly, intelligently, and legally. Because in 2025, survival depends on how fast you respond. If this video helped you, don't forget to hit like, subscribe, and turn on the bell icon. At US Immigration Intel, we don't sell fear, we explain the facts. Drop your questions below, and we'll get you the clarity you need. Stay informed. Stay prepared. And don't let one denial define your future.